the Deputy Speaker of the House of Representatives right there, Honorable Benjamin Kalu, telling Nigerians to be involved in the process of the constitution review, or constitution amendment, or brand new constitution. So we don't know the part at which the House Committee on Constitution Review or the Senate Committee on Constitution Review is going to take, but we look forward to seeing a process that is seamless, a process that is all-inclusive, a process that will put the Nigerian state first. When I say the Nigerian state now, the citizens of Nigeria. All right, we'll start up our conversation this afternoon, and I have a legal mind, someone who is not just a lawyer, he's a constitutional lawyer, a right activist. He's also a public affairs analyst. Barrister Liberos Oshoma, Esquire, joins me live from Lagos on the program this afternoon. Barrister, good afternoon and good to have you.
Yeah, thank you. Good afternoon. My pleasure.
All right, thank you for joining us on the program.
Thank you.
All right,
Thank you.
let's begin. Let's start the conversation. Let's set the part straight. First of all, can you give us a background, a brief of what a constitution really is? And the constitution we're running now, the 1999 Constitution of the Federal Republic of Nigeria, as amended. Is it a constitution of the people? You know, the preamble of that constitution says, we, the people of Nigeria. Is it really, in the main sense, is that what it really is with what we've seen over 25 years on the 1999 Constitution as amended?
Yeah, thank you, Lawrence. My pleasure once again, my first time on the program. A constitution, like we all know, is a law that governs, an entire country, a law that the people have decided, to set aside to govern the activities of the entire country. All. You have, in some cases, you have one codified law called the Constitution, and in other cases, there are, like in the case of England, there are various laws. They don't have one law called the Constitution. There are various laws. But that of the United Kingdom and Nigeria, we have one law, which we call the Constitution, which we call, the Grundnorm, which is the law under which other laws derive their title or derive their powers. And that's why we say any law that is inconsistent with that law, which is the foundation, the backbone upon which other laws are resting, that any law that is inconsistent with it to the extent of its inconsistency would be declared null and void. And being a people, relinquishing their individual right for a collective protection, and there is need to enact a law that will bind all of these people. And that's why most times you say the Constitution, is enacted by the people. And so you have the preamble to the Constitution saying we the people. But like you said, like you rightly noted, that preamble and the Constitution itself is a lie unto itself, because the Constitution was actually decreed into existence by virtue of decree number 25. A people cannot enact a law and then that law is decreed into existence. So it is contradictory. And that's why people are consistently say that the Constitution is a lie unto itself. And since that time when that Constitution was decreed into existence, there have been this search for a new Constitution. Should the existing one be amended or should there be a new one? Considering the structure of government that we are practicing, considering the ineffectiveness of our structure of government, should we be talking about amending or we have a new one altogether? And if we're going to have a new one, what will be the process of having a new one? If we're amending, to what extent are we going to amend? And that's why, if you remember, this is, there have been attempts or there have been amendment. There was the first amendment, which we call the first alteration. There was a second alteration. There was a third alteration. And then a fourth alteration. And we're on a fifth journey now. And some people also have argued that because both the House of Representatives and the Senate has committees on constitutional review, headed by the Deputy Senate President and the Deputy Speaker of the House, at every, parliamentary year now, or parliamentary tenure, by parliamentary tenure, I mean the lifespan of an administration, to draw funds for that committee, there's need to set up a constitution review committee. And eventually the constitution is reviewed, but yet it does not meet with the yearnings and aspirations of the people, and would take another 4 years. After that first 4 years, we come back again and we are clamoring to review that same constitution. You remember the last time it was the same back and forth. People went around, and then there were admonitions and call on people to reach out and try to participate in the constitutional process. A lot of memoranda were made. People clamored for state creations, but in the final analysis, by virtue of Section 8 of the same constitution, the mode of creating states, becomes too cumbersome, and then it becomes almost practically impossibility to create state. So the question people are asking, is this just an opportunity, an avenue for lawmakers to draw funds from the budget, all in the guise of amending the constitution because a committee, you have a standing committee of the House for that purpose, or is a genuine concern to actually amend a constitution that is inherently defective? Those are the questions that are begging for answer. And maybe with time, I will attempt to answer, these two posers.
Thank you very much, Liberos, for laying a foundation to this conversation this afternoon. But I have a guest who has joined me in the studio here in Benin, Dr. Mrs. Elizabeth Iyamu-Ojo, PhD. She's a senior lecturer in the Department of Public Law, University of Benin, a constitutional law lecturer for that matter, and also the Assistant Dean of the Faculty of Law, University of Benin. She had other feathers to her cap. She is the Publicity Secretary of the Federation of International Women Lawyers, FIDA, Edo State Chapter, who is with me live in the studio here in Benin. Good afternoon, Doc.
Good afternoon.
Good to have you.
Nice to be here too.
Okay, so Liberos was laying a foundation for us, the Constitution, the 1999 Constitution as amended, that we are running, telling us it was a decree by the military. It was not really the people inclusive, but the preamble told us that we, the people of Nigeria, but it seemed like we were not really carried along in the process. Now, from your own end, do you think the Constitution is, in quote, inclusive? When I say inclusive, the people.
Well, like Libor said, yeah. I think I agree with him because when you have an agreement, you have a contract. Yeah. Because a constitution, so to say, by the time it says we the people, yeah. It's essentially saying that some persons sat together, came to a conclusion and ironed out these things. These are what we want. Yeah. However, we don't know who signed for the Edo State people, who signed for the Ijos, yeah. Who signed for the Fulanis. So, who were those that comprised the meeting? Yeah. How did they come to terms? Did they discuss with their persons? Yeah. Were they nominated? Yeah. These things were not told to us. So, I quite agree with him that, yes, it was something that was imposed on us. And it may not really convey the needs of the people. Yeah. However, I am reluctant to say because it was not it was not a production of the people that it's a totally worthless document, and so we should throw it away.
Okay, let me go back to Liberos if I come back to you again. Liberos Oshoma, you've heard my guest here with me in the studio, Dr. Elizabeth Iyamu-Ojo, also a constitutional lawyer like you, who has also told us about the inclusiveness of the Constitution in terms of the people. Now, let's look at the rights of the people on this document, which we're working with. We've been using it. Okay, we'll take a break now, Liberos. After the break, I'll come back to you for the next question. We're going to break on the program. Stay with us. All right, thank you very much for staying with us still on the program. 60 Minutes Nigeria, reaching you live on independent television. We're looking at the Nigeria's Constitution, Constitution Amendment, the continuing quest for a legitimate Grundnorm for the Nigerian state. Is the Constitution, the 1999 Constitution, as amended, truly the Constitution of the people? My guests have given us a startup point on the conversation, Liboros Oshoma, who is joining us virtually live from Lagos. And my guest here with me in the studio, Dr. Elizabeth Yamu Ojo, constitutional law lecturer and the assistant dean of the Faculty of Law, University of Benin, and also the publicity secretary of the Federation of International Women Lawyers, FIDA, Edo State chapter. Now, Liboros, let me come back to you before I come back again to my guest here with me in the studio. We're talking about the right of the Nigerian citizens. Is the right of the Nigerian citizens protected in the 1999 Constitution as amended via judicial means? Can we really say the Constitution made provisions for us, you and I, my brother, my sisters, like she mentioned, the Ijos, the Benin, the different ethnic group? Does this Constitution really make provision for our rights to be protected?
Yeah, thank you once again, and I welcome my friend and sister, Dr. Ojo, in the studio. Like she said, she would not say the Constitution is a totally useless document because it was not made by the people. And now you have asked a very hydra-headed question, which is, this question alone, if we unpack the question, 1 hour will not be enough for us to unpack it, because I said it's a hydra-headed. Because at the surface level, you can say, yes, the fundamental objectives and directive principles of state policies provide, the objectives of government in the Constitution. And then after that, you have the fundamental rights that protect every right of individuals. And so, if you look at it from the surface level, you say, yes, the Constitution provides for objective and fundamental rights. And so individuals can access those rights if they feel that those rights have been violated, abused, or there is a threat to those rights. But that said, if you now look at it deeper, you now begin to talk about the ethnicities. What you call ethnicity here is called nation in other climes. What we refer to as, the ethnic group, various ethnic groups. In other countries, they call them nation. That's why some people will tell you that Nigeria is a country of many nations. So if you look at the protections of the right of those nations, that's where you now say, yes, truly, there is none. No protection for the rights of those various nations. So what we attempted to do was to create states. We create states with the hope that these states created will will understand the identity of the ethnicity of the people in those states, and then create a balance for them to coexist and cohabit. But if you also stretch it further, the question you now ask, that's why you have a lot of people agitating for state creation. Oh, look, where we are being marginalized. There is no protection enough for us constitutionally. We are being marginalized. And so we came up with this turn-by-turn arrangement, quota system, all in an attempt to have an inclusive, participation, in government. And mind you, Constitution cannot provide for everything. But if you look at it deeper, I gave an instance recently. In Yugoslavia, for example, Yugoslavia was a country of 7 ethnic groups. 7 ethnic groups. Because of the inability of others to allow a particular ethnic group to dominate, Yugoslavia today is, 6 ethnic groups. Yugoslavia today is split into 6 different countries. You have Slovenia, you have Czech Republic, you have Macedonia, so you have Montenegro. All of these are various ethnic groups. Remember, Czechoslovakia, that name that was very difficult for us to pronounce when we were young, Czechoslovakia, was a country of 2 ethnic groups. Today, there are 2 different countries, Slovenia and Czech. So, if you look at the United Kingdom is 4 countries inside 1 country. You have the Ireland, you have the Wales, and then you have Scotland, and then you have England. They understand their individual, difference. And that's why they created autonomy to protect the identity of, the nations that are coming together to form a united kingdom. And so they have different governments. They generate revenue at that lower level differently, and then ensure that that's what do you call it now? Uniqueness is maintained through an autonomy government. But here, what we have is a situation where the ethnic nationalities are not protected. The federal government, you have a nebulous behemoth called the federal government that collects all revenue and now say, okay, yes, let us share. You give to A according to population. You give to B according to size. You give to C according to derivation. So at the end of the day, you are certainly going to you are trying to micromanage. And in trying to micromanage, considering the fact also that that document was decreed into existence, you are certainly going to have all of these agitations. So now to come to your question directly, there is, if you look at it deeply, there is no protection for the various ethnic groups in the country. That is why everybody is looking for states. And if you remember the 1957 debate, 1959 constitutional debate between Chief Obafemi Awolowo and Dr. Nnamdi Azikiwe at the floor of the parliament, which till date is still reckoned as one of the most heated debates in parliamentary history in Nigeria, the argument was for state creation. Well, there was one argument that was for state creation, and Chief Obafemi Awolowo did say, if you start creating states until a Kene, my village, becomes a state, that we won't stop. And today we have a request for 100 and something states. So to answer your question, and to yield the floor to my sister, at the surface level, the Constitution seems protected of the people, but deep down, the people are helpless.
All right. Let me get her opinion on that same question. Doc, you heard everything Liberal said about if the Constitution provides, is protecting the people indeed. Your opinion? Okay.
Like he said, when he started talking, he talked about the fact that you cannot get a perfect constitution.
Absolutely.
Because we cannot get a perfect constitution, I am of the opinion that what we have with the Nigerian Constitution is not bad. It provides for the rights of the citizens. And it is the reason why we are able to enforce the rights of indigent people, even when they ordinarily cannot afford it, through organizations like FIDA, like Legal Aid. And if those rights were not enshrined there, if those rights are not there,
they cannot do
that. I remember one of the first arguments that we ever had in my when I was in 200 level doing constitutional law in Ambrose Ali University. My Professor Joe Bodion, he posed the question to us and asked us, whose rights are protected under the Constitution? Is it the rights of the state or the rights of the citizens? And we argued it out. We came to the conclusion that it is really the citizens' rights that are protected. The Constitution gives you that enabling power to fight for a right when it is infringed. So yes, I believe, personally I feel like the rights are there. They are there for the people. However, the problem we have is enforcement. When Liberos was talking, he talked about different states. We are looking at other countries, and other countries also have states. He also mentioned that if you continue to create states for ethnic groups, you will get to a point where the smallest units will have a state. That is a continuous problem. However, if everybody was being addressed properly under the Constitution, if the provisions of the chapter 2 of the Constitution were being followed ordinarily, and there's equity, we will not have a problem. We will not have a situation where people are agitating and saying my ethnic group is marginalized. So essentially for me, the problem is not the Constitution or the fact that there are no rights for the citizens. The problem is the enforcement of the Constitution.
Okay. That takes me back again to Liberos. Liberos, she has given her own thought on that same subject matter, that it is the enforcement that is the issue. Now, 25 years after of the current 1999 Constitution as amended, is there need for an amendment, alteration, or a brand new constitution? Because some persons are saying, no, let's do away with what we have 1999. It came via military decree. We weren't there. The people weren't there. Like I said earlier at the opening, the preamble says, we the people of Nigeria. But Nigerians are saying, we were not there when this thing happened. So can't we have a new one that we carry the people along? So after 25 years, should we be talking about a brand new alteration or amendment?
To answer your question, I will answer your question asking a question.
Okay.
This is the fourth amendment to the Constitution, and yet we keep amending. Some of these countries that I mentioned, when was the last time you heard them amend the Constitution? When was the last time that you heard American amend the Constitution? The problem is our Constitution is inherently defective. The more you keep patching it, it is not just the people. All those fundamental objectives and directive principles of state policies, fundamental human rights and the rest, these are inalienable rights of human beings. But how do you now operate a structure called government? What is the structure of the local government today? What is the structure of the state government? What is the structure of the federal government? The constitution that we operate says we are a federal government. But if you look at section 87, 88 and 89 of the constitution that talks about appropriation, it puts appropriation squarely, the revenue, generation of revenue, at the doorstep of the federal government. And yet, that is a unitary arrangement, not a federal arrangement. So you have a constitution that is blowing hot and cold from the same mouth. And then when you now say, let us amend it, amend a defective document, it becomes, you begin to patch it, until the people who that law is meant to protect disintegrate. The people who the law is meant to protect are saying, this law is not properly protecting us. We're just looking at the tips of fundamental rights. I told you that if you look at the fundamental rights, you say, yes, fantastic law. But if you look at the ethnic right, the right of the subnational, how do we coexist? You will say this constitution is absent on coexistence. Let me give you an instance. You have Edo State, for example. If you look at the constitution,
Liberals,
yes.
1 minute. Before you give us that instance, let's take a short break for the headline news for 2 p.m. After the break, we'll continue the conversation. Stay with us. All right, thank you very much still for staying with us on the program 60 Minute Nigeria. We've been taking a look at the Nigeria's Constitution Amendment, continuing quest for a legitimate Grundnorm. Is indeed the Constitution a Grundnorm? My guest here in the studio, and Liberos Oshoma from Lagos. We've been taking a dive into the conversation. So Liberos, you were on track before I had to cut you short for us to go on that short break. You were citing an example. Let's get to hear you.
Yeah. Yes, I said take Edo State for example.
Yeah.
We're talking about protection of individuals, and then creating a structure, a state structure that will enhance the effective protection of the right of those individuals. So it is not that the Constitution is protecting the states. No, it is the fact that the Constitution should be able to provide and create a state that will enhance the protection of the right of the individuals. Look at the exclusive legislative list of the 1999 Constitution as amended consistently. Out of both the exclusive and the legislative list, the exclusive and the concurrent legislative list, you have about 93 items, about 96 items. And of those 96 items, about 61 or 62, 65 items. 65 items are exclusively meant for the legislation of the federal government. And then you have 31 items are for the state government. And of those 31 items, the federal government can still concurrently make laws on those items. And if there is a clash, there is a conflict between the laws made by the state and the federal government, the federal government's laws would take preeminence. So what that means is that in these states, in that constitution, all of the 96 items, the federal government has supervening powers to make laws. And so where do you now leave the states that is supposed to be the government that is closest to the people for the protection of the rights of the people? And not to talk of the right of the local government. Do you know that The local government will say residual list. So any item that is not provided for in both the legislative, both the exclusive and the concurrent list is on residual. And those items are not listed. Apart from a few, bicycle registration. This day and age, we're talking about bicycle registration. And then, if you look at the entire gamut of the Constitution, the rights of the federal government, the functions and the privileges of the federal government are protected and spelled out. The duties, responsibilities, quickly, of the state government are clearly spelled out. But that of the local government is domiciled in Section 7 to the effect that the state government shall enhance their existence. And this is government that is supposed to be closest to the people, that is supposed to protect the rights of the people. If we're talking about protection of rights. So you find out that the government that is supposed to protect the rights of the people, the Constitution does not make provision for it. And so if we're talking about a Constitution providing for the people and protecting the people, then the Constitution is hanging. So that's why, even if we want to argue that no, the Constitution has provided rights, fundamental rights, the people are unable to access those rights effectively because the government keeps, the government is distant and farther from the people by virtue of the provisions of the Constitution.
Okay. Liberals, let me pause you a little bit. So I talked to Doc in the studio. I'm pretty sure she has her own perspective on that question after 25 years of the current CFRO in 1999 as amended. Is there need for amendment, alteration, or we should go back to bet a brand new constitution where the people will be carried along?
Okay, so in answering that question, I will also ask a question.
Just the way you asked the question
just the
too.
Way liberal. Now, who would be responsible for enacting the new constitution?
That's a big question.
Is it the same set of legislators that prefer to call an 18-year-old an adult, an 18-year-old female an adult, simply because she's married? Or, no, an under 18-year-old, a girl, a female under 18, an adult because she's a female.
In one section of the country.
In one section of the Constitution. And at the same time, refuses to allow the female gender give automatic citizenship to her husband in the same way that the man can do it. Now, is it the same set of legislators that, so we say they are representing us, they come from our different constituencies, and they receive 2 billion and 1 billion minimum for constituency projects, and the constituents know nothing about this thing? Is it that same legislator, the same Senate or Rep, House of Rep? Are those the same persons that we are saying we enact a new constitution that will favor Nigerians? I find it difficult to believe. Because if we are talking about a new constitution, we are trying to say this constitution will carry the will of the people, the intention of the people. We had 5 bills, gender-related bills, that were struck down in the Senate.
National Assembly.
National Assembly. Sometime in 2023. These were bills that had to do with gender rights, rights for half the population of Nigeria.
Absolutely.
But they struck it down without any consideration at all.
But
so
they have women there too.
How many women? For now, we have 109 senators and we have 4 women.
Females,
One is being driven here and there. She's been chased up and down.
Literally, there are 3 now.
Yes. So where do we get the voice? Which people are going to represent the people? Because personally, I don't think my representative is representing me.
Wow. Why would you say that?
I am a lecturer. I have been complaining for ages now that my salary doesn't take me past the gate of my institution. Do you understand? And then the person representing my constituency hasn't said anything about it. I'm a female, and we had 5 gender bills struck down. Where was my representative? Did he say anything about it? You understand? These are the issues. So when we are talking about a new constitution, are we really seeing the prospect of the persons we have put there to represent us actually representing us? So
that's a big question.
If we are going to have we are talking about a new constitution, we have to look into the modalities for getting that new constitution. Until we can get all those things done, it will just be a case of us making attempts and not succeeding. I'm sitting here, I've been a member of several committees that have tried to amend several of our laws, for instance, the Criminal Code of Edo State, Child's Rights Law. I have worked in those committees. We've worked on them for over 2 years now, but we haven't seen the finished work.
Correct.
So what is the guarantee that an attempt to enact a new constitution will see the light of day?
Okay. All right, before I go back to Liberals, let's take another short break. When we come back, we'll start looking at how to wrap up the program this afternoon, 60 Minute Nigeria. Stay with us. Thank you very much. It's still 60 Minute Nigeria reaching you live on independent television. We've been looking at the Nigeria's Constitution and Amendment, the continuing quest for a legitimate Grundnorm. Is the Constitution really the Grundnorm, or is just a mere paper that has been there for the past 25 years? The 1999 Constitution has amended. But Liberals, before I come back to you, let me get her perspective about women's affirmation in the Constitution. Now, the Constitution provides for 35%, right? While the others goes to the male gender. You were talking about having 4 females, they've been dilly-dallying 1, now literally making it 3. Do you think, as a female rights advocate that you also are, that the Constitution makes good provision for inclusiveness of the female in this current Constitution we are using? 35% affirmation. Is it really 35%?
Well, at this point, I can say that the 35% affirmation is not working.
Okay.
That is actually the reason for the reserved seats bill now, because it is supposed to be the creation of extra seats that do not vie for the same positions, but actually lend a voice for the female gender to be able to speak to issues that affect women, to be able to speak to issues that affect children, speak to issues that affect the society, because as it is now, women really don't have a say on the table. We don't have a voice. So it's a temporary thing that is expected to bridge the gap, even though it's a little, because it just means that 37 new seats will be added to the 109 seats. And those 37 seats, as extras, they still don't dwarf the 109. The men still have the larger voice, but at least we are able to articulate our feelings about things. We are able to say this is how it affects the female gender. As it is now, we don't have a voice. A little pressure and the woman, she capsizes. So I think the reserved seat bill does something that the 35% affirmative action does not do. Interestingly, it's a temporary plan for 16 years, 4 tenures, after which we go back to the drawing board and see how it works. And other countries have done that, and they have benefited from it. I think it's something that we should try.
Okay. Liberals, let me come back to you as we begin to, put the finishing touch to the conversation. Is the Nigeria state a federation in need of federalism, or the Nigerian state has federalism but does not have federation? Let's look at it critically.
Thank you very much. In answering your question, I want to say, welcome home, doctor. You said the Constitution, welcome home, because I just listened to her open book of lamentation and saying that the Constitution is not perfect, but it is okay. Yet she complained bitterly about these same people elected by the same Constitution. That's the challenge here. First and foremost, let us look at the structure of governance, because when you have a constitution that provides for a nebulous center, behemoths, a monster, everybody goes to Abuja every morning, every Monday, everybody's rushing to Abuja, and then on Friday they are coming back. Without Abuja, you can't function. there is no way you can have an effective governance or women participation with that kind of arrangement.
That's true.
That is why it brings us back to a federation in need of federalism. So you have a system. Let's assume, do you know that when we have regional government, and this regional government were autonomous, and they generate revenue from amongst themselves and then pay taxes to the center, it was easy for doctor to complain at the gate of Uniben, and before she leaves there, somebody will hear because government is closer to her. But now, if she likes, let her move from Uniben gate to Ring Road and shout, Abuja will not hear.
All right, Liberals, you are making it look hilarious right now in the studio, but that is the truth. So, but let's begin to unpack and wrap up. Doc, if there should be an amendment or alteration, how should the process be like? Doc is looking at me.
Well, this has me flummoxed.
Okay.
It's not something that I can advise
directly. This is
yes,
how it should be. Okay.
It's not something that I can advise directly on and say, oh,
okay,
if there's to be an alteration, this is how to go about it, or an amendment. But the deal is this: like Liberal said, there is no perfect constitution.
But can't we near perfect?
What we do, what Nigerians have always done, is to copy and paste. We take from one country, we bring back, and we copy. And sometimes in the course of copying, we do not copy with sense. We copy everything, hook, line, and sinker, and we don't do the needful. Ordinarily, when you take and you are copying, you should look at the peculiar circumstances of your country, of your ethnic components. However, that was not done.
Okay. So
my position really is that at this point, when you're talking about alterations, it's a big deal. Are we looking at the fundamental objectives and directive principles of state policy?
Okay.
Are we looking at those things that ordinarily the government should provide, but they have fixed in chapter 2 and says that by virtue of section 6 of the Constitution, these things you cannot take the court. You understand?
Not justiciable.
So is that what we are looking at? Or we are looking at the rights? Liberals talks about structure. Structure is a very big part of the Constitution that needs to undergo amendment, or for want of a better word, like he says, a new constitution. But either way, for all its worth, whatever efforts we are making has to be followed by political will. If there is no political will to do the needful, nothing works. We have a country that is corrupt. So when you are talking, the way corruption has covered everything, there's no part of our democracy that has not been infiltrated. So with it the way it is, it's really difficult for you to say, oh, this is how it will go and this is how it will really go. You understand? So for some of us, we just feel like even if you bring the perfect constitution,
there will still be a problem.
The problem will be enforcement. And that is why my final words really are that our problem is not really the Constitution. Our problem is the lack of political will and lack of enforcement.
Okay, Liberals, let me come back to you. Your final take on this. How should the process of amendment or alteration be like? Should it be a system where they will call for a town hall meeting that is not different from a ballot blue? That was on the lighter side anyway. Or everybody should go to the National Assembly and meet with their representatives and say, this is how we want it. The process.
They say if you are having your bath and a madman take your clothes, do you run out of the bathroom and chase the madman naked? Or you stay there and call for a new tower? That's where we are now. We are not going to begin to gather people again to say, oh, let's hear this opinion. We already had somewhere we started from. And that we were doing fine until it was truncated. The companies and the industries that we built with that constitution, till today, we cannot replicate them. I grew up under Bruce Ali, so I know what I'm talking about. Do you remember the case for constitutional laws student that you are? You remember the celebrated case of AG Bender State and AG Federation on revenue allocation?
Yeah.
So when
do we still have the judges that will drop that kind of landmark decision?
Do you know? Yes, there are judges that will do that. The problem here now is that the government is far from you.
Yeah.
Do you know that if it is a regional arrangement and all the revenue comes from the region, without us going to Abuja, we go kill ourselves for Benin. But because the money comes from Abuja, feeding bottle, so you say the location won't come. So that is the problem. So when we have that arrangement, there is no need sending people to Abuja to go and elect or to change constitution for us. All of us will be at the regional level. We'll have an autonomous constitution that will give us an autonomy on how we can govern ourselves. And so we don't have a bogus arrangement. It becomes easy to manage. A house that is too big, some Omila go hide for some corner. But if it is smaller, it is easier to manage because of the nature side of it. That is why it is becoming difficult. We need to go back to those regions. Do you know that before rounding up, University of Benin was not built from funds from oil. The University of Ife was built from cocoa funds. Do you know that Ahmadu Bello University, which is the largest university south of the Sahara, was built from funds from granite? But today we had oil. And so we all rely on that oil. And truly, it is not for the National Assembly to amend constitution for us. They cannot amend it. It is for us. You have constituent assemblies. It is for these constituent assemblies to come up with a document. That document, it is what should be going around to different zones now. And not the National Assembly telling us to come and gather and tell us what we want. It is the document that should have been going around now. And we're taking a referendum on it, the way a referendum was taken to create Midwestern states. That is why I'm telling you that this jamboree will not produce anything. Thank you.
Okay. Liberals, we're pressed for time and we have to go. I really want to thank you for your time, your insight, your analysis. On point, perfect, top notch. And I also want to thank the doc seated here with me in the studio, Life and Benin City, for your time as well, for carving out time for us to have this conversation. We'll continue to monitor this process and see what happens at the end of the day. Thank you very much for joining us on the program. And that's the size of our package on the show, 60-minute Nigeria. A lot has been said, but we'll look forward to implementation, which has always been the problem. But we hope this is not different from others. I am Lawrence Osifo. I'll see you again. Bye for now.